A very good morning to all my dear students. Today we are going to discuss about the drafting of general power of attorney under the subject captioned as drafting, pleading and convincing. My dear students, before starting with today's topic, I just want to recapitulate certain important points which needs to be taken care by a law student or by a lawyer while drafting a power of attorney. As you all are aware, power of attorney is a compound expression formed by the words power and attorney, meaning thereby it contains two words, means power and attorney. Now I just want to explain you the meaning of power. Power is an authority given by one person to another to act for him or to do certain specified acts, meaning thereby in this power of attorney, an authority is given by one person to another to act for him or to do certain specified acts pertaining to the subject matter mentioned therein. In Bowier's Law Dictionary, power has been defined as follows. It is the right, ability, or faculty of doing something. The distinction between power and right, whatever may be its value in ethics, in law, it is very shadowy and unsubstantial, meaning thereby he who has the legal power to do anything has the legal right. Technically, an authority by which one person enables another to do some act for him is known as power of attorney. Salmond on jurisprudence defined the word power as a power may be defined as an ability conferred upon a person by the law to alter by his own will directed to that end the rights, duties, liabilities, or other legal relations, either of himself or of other persons. Meaning thereby, power is either the ability to determine the legal relations of other persons or the ability to determine one's own. The first of these over other person is sometimes called the authority, and the second power over oneself is usually termed as capacity. Now I just want to explain you the word attorney. Attorney is a person who is appointed by another to do something in his absence and who has to act in place and in turn of the persons by whom he is delegated. Generally, the persons so appointed are of two types. Number one, attorney at law, that is, a person to whom power of attorney is given to plead the case and to act for his clients. And all the acts done by the person on behalf of his client during the continuance of the appointment bind the client. And number two, attorney, that is a person who is given a power of attorney specially for an act or generally for a series of acts to represent him in any business or act by virtue of that power of attorney. So my dear student, this is the meaning of attorney. Before this, we had also discussed the meaning of power. Now I just going to give you the meaning of power of attorney. As far as the word power of attorney is concerned, it is the document authorizing another person to do any lawful act on behalf of the person executing it, meaning thereby unlawful act is not permitted to be taken care under the general power of attorney. And if the general power of attorney contains any such clause regarding the unlawful act, then the court, after looking into the document and while interpreting the same, either the said clause would be termed as null and void, or the court may declare the said document as null and void in the eye of law. Now, before I would like to go into the today's topic, that is drafting of general power attorney, I would also like to explain you one question, and that question is whether an attorney is competent to dispose on behalf of the principal. To this, my answer is attorney is competent to depose in respect of all the matters except matters which are required to be done personally by the principal. Statement of power of attorney holder can be read as statement of party to the litigation. This was so held in the case of Satnam Chanua versus Darshan Singh, AIR 2007, Doc 216, Punjab and Haryana High Court. Further, my dear students, as far as the law relating to power of attorney is concerned, it is submitted herein, or it is relevant to point out that the law relating to power of attorney is dealt within the Power of Attorney Act 1882. The various sections of the Act containing provisions for creating power of attorney and other salient features are given below. Number 1, Section 2 of the said Act provides execution under the power of attorney. Section 3, payment by the attorney under power without notice of death, etc. Deposit of original instrument creating powers of attorney under Section 4. Power of attorney of a married person, Section 5. And registration of the power of attorney has been dealt under Section 32 and 33 of Registration Act. Meaning thereby, while drafting a general power of attorney, one must have to keep in mind the three interrelated laws. That is the Power of Attorney Act 1882. Second, the Stamp Duty Act that is Article 50 Clause B of the Stamp Duty Act and the Registration Act, as the case may be. So with this background, my dear students, we are now going to draft a general power of attorney. As you all are aware that while drafting any kind of deed, we have to describe the deed, wherein we have to give the name to the title of the deed. And the title to general power of attorney deed is concerned, we can give the title, or we may give the title as general power of attorney. Now we have to explain the parties to the deed as such. So we may write it as under. Number 1, know all men by these presents that Messrs. Y Limited, having its head office at so and so place, that is Akbar Road, New Delhi, in this particular example or format which I am providing it to you, or which I am presenting it to you by way of this slide. Hereinafter called, the company appoint Mr. Z, son of Mr. ML, resident of so and so, hereinafter called the attorney, as its attorney to do all deeds and acts which the company is authorized to do through an attorney. The said attorney shall have the following powers to do the following things. So meaning thereby, you can give the description of the person who is executing the general power of attorney, as well as the attorney description as well in this particular paragraph. Further, you may also explain the nature of this document, that the said power of attorney shall have the power to do the following things on behalf of the executant, that is the company in this particular instance. Now these are the powers which you may put in the general power of attorney. Number 1, that the attorney shall carry out the business of the company to the best of his ability and capacity in the interest of the work. Second, the attorney shall purchase or otherwise acquire any movable or immovable property in the interest of the company, meaning thereby that it is the duty of the attorney to carry out the business of the company as per his best ability. So my dear student, if he is causing loss to the company by his acts, then he would not get the protection of the said document, and he would also be liable in the court. Further, the attorney shall purchase or otherwise acquire any movable or immovable property in the interest of the company, meaning thereby he cannot go for the purchase of any movable or immovable property for harming the interest of the company. Meaning thereby he has to do work in the fiduciary capacity, and thereby not to create loss to the company. Further, the attorney shall work, manage and develop the property or undertaking in the interest of the firm. Further power may be given to the attorney is that the attorney shall manage and supervise manufacture and sale of the goods in the best interest of the company. The attorney shall be the overall in charge of the staff. He shall appoint, suspend and terminate manager, accountant, steno, typist, peon, etc. as and when he thinks proper and in the best interest of the company. Meaning thereby, if the employees of the company are not working in the best interest of the company, then he has the power under this power of attorney to remove them from their respective works delegated to them by the company. Further, the attorney is authorized to enter into any kind of contract, execute and perform all obligations, and receive and accept all benefits for and on behalf of the company. Meaning thereby he has all the powers to do all such acts which are in the benefit of the executant, and thereby to protect the company from any kind of loss. Further, the attorney is authorized to enter into, make, sign, and to do all such agreements, receipts, payment, and contract, etc., as he thinks fit and proper and expedient in the interest of the company. The attorney can mortgage the property if he thinks proper and expedient for carrying out or carrying on the affairs of the company smoothly. Further, the attorney shall adjust, settle, compromise, and submit to the arbitrators all accounts, debts, claims, demand, disputes, and matters which may arise between company and person or persons from time to time. Further, the attorney shall draw, accept, endorse, negotiate, retire, pay, or satisfy any bill of exchanges, promissory notes, hundays, checks, drafts, etc., which he thinks necessary and expedient in the interest of the company. So from all these, my dear student, you may infer that he can enter into any kind of contract with anyone, even also to mortgage the property of the company, but that too only for the best interest of the company, and thereby not to cause any loss to the company as such or to the executant as such. And if he puts losses and the same has been done in good faith, then he would be protected from criminal litigation against him. But in case it is found that he has put the loss to the company deliberately and with the malefied or with ulterior motive or with malefied intention, then in that particular circumstance, he would be criminally responsible and he would be charged for the respective offenses under the Indian Penal Code as such. Further, the attorney shall borrow from time to time any sum by pledging movable or immovable property of the company on such terms as he thinks fit or proper in the interest of the company. Further, the attorney shall open a bank account in the name of the company in any of the nationalized bank and shall operate it as the managing director of the company. The attorney is authorized to close the bank account already running and open the account to some other nationalized bank as and when he thinks fit proper in the best interest of the company. Further, the attorney is empowered to invest the money of the company in the best interest of the company as and when he thinks it proper. Further, the attorney is empowered to commence and prosecute and to defend, compound and amend all actions, proceedings, suits and claims in relation to the business and property of the company. Further, the power attorney is also empowered to appoint advocate or advocates to look after the matter in the courts and government offices relating to the executant herein, that is the company. Further, the attorney shall represent the company before the department of the state government or of the central government or before any local authorities and vote at any meeting in any form companies or government departments for and on behalf of the company. The attorney shall appoint some insurance agent for insurance of the stock, building, plant and machinery and other movable and immovable property. Generally, the attorney shall do all other works concerning with the affairs of the company to the best of his ability in the best interest of the company. Further, the company agrees that all works done by the said attorney shall be binding on the company. And at the last, there must be a testimonium which may be written as I execute this power of attorney in the presence of the following witnesses, wherein the witness number 1 and witness number 2 details may be put. And thereafter, on the right hand side, for the company, the MD or the person authorized or the person by whom this attorney has been appointed may put his signature along with his designation as such. So my dear students, this is all about today's lecture. Hope you have learned a lot out of it. In case you have any query with regard to the drafting of the general power of attorney is concerned, then you may write it to me at my email ID, that is rahularora.gn@jagannath.org. But before parting with today's lecture, I just want to apprise you with my new topic, which I am going to take in my next lecture. And my next lecture would be on the drafting of will. Thank you very much. We'll meet you soon in my next lecture. Till then, stay home, stay safe, and stay healthy. Thank you very much again.